Hi, y'all, and welcome to tonight's live stream. It's our second live stream of the day. Today, the Karen Reed jury finally reached an impasse. The judge read them the dynamite charge known in Massachusetts as the Tui Rodriguez charge, the one we talked about last week, and gave them the strong encouragement to try to compromise, try to reach a verdict if they could. And nothing doing. They could not reach a verdict. They came back again saying they would not be able to agree. They really, really couldn't agree. And the judge declared a mistrial. It was a hung jury, and she declared a mistrial. And just like that, 2 months of efforts, and that's just the trial part, came to a crashing end, deeply unsatisfying demise of the trial. There's not going to be a verdict. We are not going to get a resolution this time around. And instead, the judge is pushing forward immediately to a new trial. So the DA announced right away that Karen Reed, in fact, would be retried. We're going to talk about all of that. This case has been deeply divisive. We're talking about not just within the jury. Obviously, it was divisive there, but we are also talking about in the community, in the public, in the chats about the trial. In the courtroom, out of it, people had wildly differing views of whether Karen Reed was guilty of murdering her boyfriend, John O'Keefe, by running into him with her car, causing blunt force trauma to his head and leaving him to slowly freeze to death in the middle of a Boston blizzard. Now, this case was deeply controversial in the Canton community, which is outside Boston and where John O'Keefe lived. People protested outside the nearby courthouse, which is where the defendant was being tried, saying she was being framed. People showed up at local Canton council meetings demanding answers and an audit of the police. What is it that makes this case so controversial? Why do we disagree so much about this case? Tonight, I want to take a look at the why, the reasons that this case has been so deeply controversial by taking a deep dive specifically into the evidence itself, what it is about this evidence that splits us. What is the key evidence for the prosecution, for the defense, and why is that making it hard for the two sides to agree? So we're going to have 4 parts for what we're going to cover tonight. First, we're going to talk about what the jury said about not agreeing, what they told us about how they couldn't agree. The second, we're going to talk about the key facts on both sides. And we're going to talk, then thirdly, we're going to talk about why those made it so difficult to agree and the elements that the prosecution had to prove for the jury to find Karen Reed guilty beyond a reasonable doubt. The fourth thing we're going to talk about is what's next for the trial. So to our Canadian listeners, I want to say Happy Canada Day. And I want to say a special welcome to our first 5 in the live chat tonight, which would be Shu, LMA1, aka Sue, Fluffy Hedgehog, Sweetie, and Misconstrue. Welcome, special welcome to all of y'all and to everybody in the live stream tonight. I also want to give a special shout out to Katie and Rose and Karen and Carol from Boston. So if you would hit that like button as we head into this, subscribe. We would love to have you back for more, and let's get started. I want to start with what the jury said about disagreeing, what they told us about how deeply divided they were. I want to pull out just the notes they sent to the judge and let you hear them, the ones we got today, because there were 2 that came in to the judge. Remember that the jury was given an instruction late on Friday that said, they wanted to stop. I've forgotten what time it was, but they said, we can't agree. And the judge said, keep trying. But she said she wasn't yet finding that they had finished their deliberations, due and thorough deliberations. So she wasn't going to give that dynamite charge. And then today, after a couple of hours, they sent out something saying we can't agree. Then she gave them that dynamite charge, and it didn't make a difference. They once again said they couldn't agree. So let's take a listen to what it is that the jurors told the judge.
So, jurors, I am in receipt of your note. Judge Canoni, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. the divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds.
That was the first, the one from this morning, where the jury explained why it couldn't reach agreement. And I want you to think about some of the words that they used. Deeply divided, they called themselves. Fundamental differences in our opinions and state of mind, not just small differences, fundamental differences, complete radical disagreement, not rooted in a lack of understanding or effort. In other words, it's not that we don't get it or that some people on the jury just really don't seem to understand. It isn't that we aren't trying. We're making every effort and we do understand, but, and this is a quote, deeply held convictions prevent us from agreeing on this. And they even told her, we recognize the weight of this. We recognize the implication. We understand what this means, which is that the entire case would have to be retried, that there's no verdict after 2 months of trial. And here's the juror note that they sent in the later afternoon, the final
All
one.
right, Mr. Foreman, I am in receipt of your note. Judge Canoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs.
So think about what was said there. Our perspectives on the evidence are starkly divided. Stark division. Really, one over here, one over there. We are nowhere near each other. Really solid division between us. Some members of the jury believe that the evidence surpasses the burden of proof, establishing the element of the charges beyond a reasonable doubt. There are several clues right in that sentence that I don't want us to overlook. The first is it said some members of the jury believe that the evidence is that she was guilty beyond a reasonable doubt. That suggests more than one person thought that. This was not a situation where 11 members of the jury wanted her to be not guilty and one wanted her to be guilty. No, it's saying that some members, more than one person on the jury, believed that she should, and notice it doesn't say establish the element of one of the charges beyond a reasonable doubt, but the elements of the charges, plural, suggesting that a group believed she was guilty of more than one of the charges. And it wasn't just one person and it wasn't just one charge. This was a significant finding among them that it was more than one of the counts. That's the hint there. And conversely, others find the, again, plural, so more than one person was on the other side, find this evidence fails to meet this standard. They do not believe she is guilty beyond a reasonable doubt. And again, says this is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. So we really believe this. It's not like we just are being difficult or we haven't listened to each other. We really believe different things. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Taking this to such a fundamental level, this is truly what they believe, and they are truly different, and it's more than one person on either side of that. That is really important information because it suggests to us that there were camps on either side. Some believed Karen Read was guilty and some did not. We'll find out, I imagine, over the next few days what the division was, and we'll find out. Hopefully, we'll be able to talk to some of the jurors. And by the way, let me say this. If any of you know someone who served on the jury, I would love to interview one of the members of the jury. And if you would ask them to contact me, I would really be appreciative. I would love to do that. I also would be willing to guess that the foreman must have been in the first category, believing that she was guilty. And the reason I say that is the use of the word some members of the jury firmly believe. And that wasn't used with the other. It was no less true that a group didn't believe that. But the firmly was only applied to one side. So that was just my guess. Maybe the foreman fell into that camp. And I'm also guessing maybe this was slightly in the minority just because he added that adjective. We'll know. We'll see. We'll find out. So I would be really curious what you are thinking now. But first, let me show you what you were thinking at the time of, let me pull up. Well, darn it. Well, I was going to tell you what you were thinking when I did the poll, and I can go ahead and tell you, but I can't find it right. Oh, here we go. No, that's not it. I don't know. I'll just tell you basically about when I did the poll this morning. I was curious, where do people think the jury is likely to come out? And about 53% of you thought that the jury was likely to come out as hung jury. Not very many of you believed that it was likely to come out with all guilty. In fact, it was only 2%. And the others believed it was either partially not guilty or maybe a mixed verdict. But the largest number by far suspected that it would be a hung jury. And that, in fact, is the way it came out. Honestly, I thought the same thing as well. Oh, look at that. Here's that poll. Let me add that to the stage. So there we go. So this is what y'all thought. And at that point, almost 10,000 of you had voted. So 2% of you thought guilty on all counts, 12% guilty on some, not guilty on others, and 29% not guilty entirely, and 57% said hung jury, that the jury won't agree. So pretty much y'all were correct. And the question was not how do you feel or what do you think, but what do you think the jury is thinking? Which way do you think they will go? And so that was what you were thinking, your best guess as to which way they would go. So let's move over into the section where I want to talk about what the top facts were for both sides and why it is that I think they were so divisive and why it is that I think that people could not agree on that. Let's start with the defense, Karen Reed's side. And I want to go with 5 critical facts that I think shaped most people's opinions who believed that Karen Reed was not guilty, who believed she should not be found guilty of this. So let's go ahead and start the video.
Steps and you're descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Reed was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to 1 Meadow. Recall.
So point number 1, fact number 1, is that John O'Keefe's watch or phone registered a combination of stairs and steps right during the critical point. In other words, the defense says he couldn't have been riding in a car. He had to have been walking into the house at 34 Fairview. And if he went into the house, then it's not Karen Reed who killed him. It is the people inside the house who killed him. And furthermore, he did more steps after she had left. How would that be possible, they ask? If Karen Reed killed him, he wouldn't be walking. The whole point was he was, according to the medical examiner, immediately rendered unable to move or to react when he had that dramatic, very significant head injury. And so if that happened, then it wasn't Karen Reed who killed him. It was John O'Keefe walked into the house, and then there was something else that happened to him. Just so you know, FYI, my dad's, he lives with me. We talk about dad a lot. My dad's view was this was what was the most persuasive fact for him. He would have gone not guilty right here on this fact. I'm going to ask you at the end what your most important facts are. So I'll do the other 4, and then we can do our survey. It'll be an informal survey. You can just put it in the chat or the comments. So the second major fact was the unexplained arm injuries on John O'Keefe. Did they come from an animal attack? That's what the defense says. The prosecution, frankly, had very little explanation for it. They said it came from the shattered taillight of Karen Reed's car, but that left some unexplained facts, like that there was no blood on the pieces of the taillight. That left some confusion. Here's what the defense said about those scratches on the arm.
What Dr. Russell said. She's seen up to 1,000 animal attacks. In her expert opinion, John's right arm, those injuries are from an animal, quote, most likely a large dog. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jim McCabe admitted, yeah, I didn't see her there. But they actually got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they had had for 7 years. Also a dog who had a bite history.
And that fact made a lot of people believe that something attacked John O'Keefe, and what animal would there have been other than the dog inside the home, Chloe? It seemed like the most likely place those scratches could have occurred. They didn't look like something from a taillight. They looked more like something from the claw of a dog. And so I think that was very persuasive to a lot of people. The third fact is the unexplained wreck sequence and the lack of injuries from the neck down. One of the prosecution's biggest flaws in their case, I thought, was that they really did not provide any adequate explanation for how exactly John O'Keefe's injuries occurred. If he got hit by the car, how did it all work? Trooper Paul mentioned, well, maybe he hit his head on the curb, but it wasn't really explained. That didn't seem to make a lot of sense. And if he did, how did he end up on his back a number of feet away? How did it all work? We didn't get a great explanation. Here's what the defense said.
They cannot and haven't even tried to explain the lack of injuries on John's body from the neck down. Nothing. He was pristine. Not a bump, not a bruise, not a fracture, not a broken bone. Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour. And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision, the whole collision, with that 3.5-ton SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get a bruise. So how are those injuries properly explained? The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself.
So the fourth fact is that taillight. I don't know if there's any piece of evidence more controversial in the whole case than that taillight. The defense says the taillight was cracked, at least only cracked until Trooper Proctor or maybe other people broke it out so they could have pieces of the taillight to sprinkle at the scene to be discovered by other law enforcement personnel. The prosecution says that taillight was broken because you, Karen Reed, backed into John O'Keefe. The pieces were around him because the taillight broke when you rammed into him. That's what happened. So here's what the prosecution had to say.
Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged.
Now, I may have said the prosecution said that was the defense. We're talking about the defense's key facts here. So that was the defense. So in addition, as I mentioned, there was no blood found on the taillight. So how did it create these scratches without getting any blood on it? And there was the alternative theory that the defense floated about Karen's broken taillight having gotten cracked or broken when she, on video, we saw it on video, backed into John O'Keefe's car, which was parked behind her as she went out to find John O'Keefe. So the fifth fact was the snowplow driver's testimony. He testified about two important facts. The first is this one.
3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow. And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning.
And that was just the first issue, because he also talked about there being another vehicle right where the body was, right in that area, a Ford Edge. Brian Albert, there was testimony, owned a Ford Edge. And so that was part of the way that the defense planted some doubt to suggest that someone other than Karen Reed put John O'Keefe's body right there. So, all right, give me your opinion. Take those five and we're going to number them, and you tell me which was most important to you. We're also, don't worry, going to cover the prosecution side. We cover both sides here. So point number one was the stairs and steps. Point number two was the arm injuries, animal attack. Number three was the unexplained wreck and the lack of injuries from the neck down. Number four was the taillight being only cracked or not broken. Number five was the snowplow driver and what he had to say. So number one, well, I'll do it one more time. Number one, the stairs and steps. Number two, the arm injuries, animal attack. Number three, I'll shorten it to lack of injuries from the neck down, just doesn't seem to fit with the wreck, in other words. Number four, taillight being only cracked. And number five, what the snowplow driver said. And I'm curious what's your numbers. Oh, people are a lot of twos and threes. Oh, well, I don't think there's any number not picked. I think y'all have picked every number. And I'm not seeing very many fours. I'm seeing a lot of twos and threes. And okay, so let's keep marching on. A couple of other points I want to make, and I'm going to unpack these a little bit more in a later video. But there were two other areas. These weren't exactly facts that related to how John O'Keefe died. These were more circumstances that the defendant used to make the point that they believed Karen Reed had been set up. The first was the belief, the insistence that the police investigation was not full and fair. There was a failure to investigate people who well might have been involved or might have had information. Key witnesses weren't interviewed for a year or so after the incident where John O'Keefe died. And there was also that truly inexplicable behavior by Trooper Proctor, the lead investigator. He made a quick decision that she was guilty and immediately the same day reflected it in who he interviewed and who he did not interview. He waited a year, as I said. He also wrote to friends who were not police officers and made truly appalling comments about the defendant, calling her a whack job, saying F her, zero chance she skates, she's effed. As he was looking through her phone, he made crass comments to an officer about looking for photos of her unclothed. He discussed her private health information in a way that was calculated to embarrass her and for no reason whatsoever. It was not needed for the case, and these weren't law enforcement personnel. So I'm going to be doing another video on the troopers and what they did to sink the case. And so be sure to subscribe. If you're not subscribed, then please do. And we will, because I'll be doing that, and I think you'll really be interested in that video. So then the second major area was the police. The first was the belief that the police investigation wasn't full and fair. And the second was that there was just generalized suspicious activity by the police and by the people in the house. And all of that sort of went together into the general belief that it was, for many people, that it was difficult to believe the testimony by the prosecution, and specifically by the prosecution troopers. They just didn't believe what they had to say. They did not feel they could trust them. And then finally, I think one of the biggest points was that the medical examiner would not say that this was a homicide, wouldn't even say that this was a car accident. And I think that was powerful for a lot of people.
No evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe, or that Karen Reed ever wanted to strike John O'Keefe. In fact, every single piece of material evidence in this case unequivocally proves the opposite. Concerning John's injuries first, the Commonwealth's own medical examiner, Dr. Scortibello, could not conclude that John was hit by a car. Think about that. And she would not even say that it was a homicide. She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto-pedestrian accident. That by itself is reasonable doubt. Dan.
And right there, I think that was a significant point for a lot of people. The fact that the experts on the prosecution side didn't necessarily support their theory of the case. On the other hand, of course, the defense experts did, which is what you would normally expect.
Wolf and Dr. Andrew Rinchler explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there.
I hit him.
Okay, let me stop and pull that out, because I want to add this to the stage and take you to the charges and elements, because now what I want to do is talk about those points, how those points made it impossible for people who believed the defense arguments to find Karen Reed guilty in this case. It would be impossible. Let's take a look at this particular slide. This is the slide I did. I took each of the charges against Karen Reed and then listed out the elements that the state agreed it had to prove in order to convict Karen Reed. And take a look at some of these. And we're not going to go through point by point. Instead, I want to direct you to some specific ones. So with second-degree murder, assault with intent to murder, the very first element is that Karen Reed had to have caused the death of John O'Keefe. If Karen Reed did not hit John O'Keefe, if that fundamental fact isn't true, then this could never be true. The jury could never find second-degree murder. And then take a look at the next one, manslaughter while operating a motor vehicle while under the influence of liquor. The very first part is that she has to have been operating a motor vehicle. And number 4, wantonly or recklessly, and by doing that, caused the death of John O'Keefe. So if she's not the one who caused the death of John O'Keefe, then automatically they cannot find her guilty. And let's look at the 2 lesser included charges, the first being involuntary manslaughter. And let's take a look at number 1, defendant caused John O'Keefe's death. And it was wanton or reckless conduct is number 3. Well, again, if Karen Reed isn't driving the car or doesn't hit him, then it doesn't match. It doesn't fit with this. So if the jury doesn't buy that the taillight pieces were there, that they came directly from Karen's car, that she hit him with her car, they can't possibly find her guilty even of this lesser included charge. And then let's go to the next one, lesser included motor vehicle homicide, felony, OUI, liquor, and negligence. Again, there has to be operated vehicle in a negligent manner. And if she was simply driving and did not hit him, did nothing unusual or wrong, and that would be element 4, and element 5, by operation of the motor vehicle, caused the death of John O'Keefe. So you can see how none of these fit. If the jury doesn't buy what the prosecution is saying, if the jury believes the defense, none of these fit. None of the arguments make sense. And the last one would be similar to that. go to number 4, the collision caused injury to John O'Keefe, resulting in his death. And go to number 3, that the defendant knowingly collided with John O'Keefe. So if she had no clue it happened and it didn't happen, none of this really fits. None of this makes sense. Let me go ahead and pull that out, and then we can talk a little bit more. So the people who were on this side in this camp concluded they could not accept the police conclusion that Karen Reed hit John O'Keefe in the front yard and knocked him into the front yard. They might or might not believe that someone else did it, but they couldn't accept that the taillight pieces were there as a natural result of a collision between Karen and John O'Keefe. And so that meant they fundamentally didn't buy that Karen Reed hit John O'Keefe with her car at all. At least that's my guess, because that's what I believe was across all the live chats that I saw. That seemed to be an issue that a lot of people could not accept, did not believe. So now let's take a look at the top facts that the prosecution believes supported it. And we're going to take the other side of that and understand why these two sides can't agree. So let's start with, and I played just a clip of it, a second of it before I stopped it. This is the beginning of the prosecution's closing argument, where he points out Karen Reed's admissions or statements that she made. And Karen's words were a centerpiece of what the prosecution said made her guilty, made them know she was guilty. And if you believe the witnesses who said these, and some of them were just first responders, and this is what they said, Karen Reed herself said. So here's the prosecution argument.
I hit him. I hit him. Those are the words of the defendant. 4 times. You heard testimony from 4 different witnesses who overheard and observed those statements from the defendant on January 29th, 2020. Both Kaylee and Ms. McCabe indicate that the defendant initially indicates or says that she got into a fight with Mr. O'Keefe and left him at the waterfall. From this information, Ms. McCabe then testifies the defendant indicates to Ms. McCabe.
And so far we've heard what we know the prosecution said, which is that Karen said, I hit him, I hit him, I hit him. She acknowledged hitting him. That's the prosecution position. And she also made the statement that she left him at the waterfall, which would not make sense if she had no idea what had happened. If she had taken him and knew she had taken him to the party and she truly thought he had gone into the party, why would she believe she had left him at the waterfall? That's the prosecution argument.
Maybe I hit him. Did I hit him? She then calls Ms. Roberts at 5 a.m. on the dot, indicates John's dead, hangs up the phone, calls back a minute later, indicates that Mr. O'Keefe was now hit by a plow and that he's dead. And then indicates further that she's drunk and doesn't remember. She tells Ms. McCabe about the cracked taillight before they even get in the vehicle and go anywhere. At 5 a.m., the defendant calls Kerry Roberts, saying, John's dead, Kerry, hangs up the phone. 5:01, the defendant calls Kerry Roberts again. And it's at this point that she indicates that John's dead, he must have been hit by a plow.
And so the argument the prosecution is making is these statements only make sense if she has some vague idea in her head that she must have hit him the night before. Why would she's at home, her boyfriend hasn't come home. Why would a woman's thought immediately go to, well, he must have been hit by a snowplow, or I must have hit him the night before? That wouldn't be a normal reaction the prosecution is suggesting. The normal reaction might be to think he went somewhere else, he was sleeping it off, whatever. But for her to drive back to the waterfall doesn't make a lot of sense. For her to tell people that she thinks he's dead doesn't make a lot of sense. Why would she think he's dead? And that's the prosecution argument. And then finally, this point.
Darkness, in the snow, in the blizzard, in those conditions, the defendant, sitting in the back seat of the vehicle, knows exactly where Mr. O'Keefe is, covered in snow, as you heard from all of the paramedics, from the civilian wings. They then get in the vehicle, they drive back towards Fairview Road, and again, the defendant, from the back seat of the vehicle, immediately sees the defendant starts pulling and kicking on the door, and runs in sort of a beeline straight over to where Mr. O'Keefe is laying on the front lawn. You have the
And the prosecution argument is the only way Karen Reed knew where John O'Keefe was is because she had hit him the night before. Otherwise, how would she have known that? She saw his body before anyone else could. It was covered in snow. How would she know that? And yet she did. And that's the argument that the prosecution is making. So I need to say thank you to a couple of people. First of all, and welcome to our new members, Legal Cat and Brandy. Welcome. Glad to have you. Helen, yes, I will tell you if I think Karen Reed is guilty or not. We'll wait till the end. Mama Pinks, thank you for gifting 5 Lawyer League memberships. Mama Pinks and Marlon are our 2 moderators, and we are very grateful to them and thankful for their support. I will tell you that. Okay, so there were also some physical evidence pieces that the prosecution believed really showed that Karen Reed was guilty. And this one, I think, was probably the most important.
Clear and Ms. Hanley in regard to the microscopic pieces, 1/16 of an inch by 1/16, all consistent with pieces of taillight that are found within.
So they were saying there weren't just pieces of taillight scattered around John O'Keefe at the scene. There were also pieces embedded in his clothing. And while it might be possible for people to take little pieces and scatter them around and so that others could discover them later, it would be much harder to embed little pieces into somebody's clothing. The prosecution believes that could only happen if, in fact, those were embedded in his clothing because he actually got hit by Karen Reed's car and the taillight pieces got into the clothing then. And of course, the prosecution believes that Karen was drunk, very, very drunk, and that Karen and John were fighting. They played in closing some of the statements that she made or talked about the texts that were done. One where John O'Keefe told her, OMG, stop calling. Another where she screamed, John, I hate you, on the phone, leaving a message for him. That was actually after he had, according to the prosecution, been killed by Karen Reed. So let's take a look. Let's go back into our slide of the charges and see what the issue is here. So if you believe, and if a juror believes that there actually was a collision, that those taillight pieces embedded in the clothing and around John O'Keefe mean he was hit by Karen Reed's car, well, then now there becomes a real question. She caused the death. The issue on second-degree murder is, was it intentional? Did she actually mean to? And the evidence that the prosecution offered about their fight would be the support that the prosecution thinks goes directly to that point. Now take a look at the manslaughter while operating a motor vehicle while under the influence of liquor. If you already believe that there actually was a collision, then go to number 4. The question left really is whether the vehicle was operated wantonly or recklessly. So did she recklessly back up fast? Remember how it was 60 feet at 24 miles an hour on an icy day? Did she back up knowing he was back there and not really pay any attention? Was that wanton? Was it reckless? Same would go with the lesser charges, that she intended the conduct, maybe even because she did become drunk and nonetheless operated a car, that it was wanton or reckless. The lesser included motor vehicle homicide, operated it in a negligent manner and caused the death. And finally, leaving the scene of a collision resulting in death, if you go to number 4, caused the injury to John O'Keefe and knew that she collided with John O'Keefe. And the phrases like, did I hit him? Could I have hit him? Or I hit him. Any of those phrases could suggest to the jury that she knowingly collided with him. Maybe she was somewhat blacked out or somewhat confused, but she later seemed to remember hitting him. But where was I? Was I at the waterfall? Where was I? And she didn't remember driving him to the party, perhaps because she had had so much to drink. So you take a look at that and you can see why it is so fundamentally difficult for people to agree, because they are disagreeing on the ultimate question of whether or not this accident even occurred. And part of the reason why people might not buy the prosecution's case is because you can believe the other side's witnesses and they support the other side. So let me explain what I mean. You could, if you believe Karen Reed's statements, those are statements by the defendant herself. So you could believe what the defendant said. I hit him. Could I have hit him? He's dead. You could believe what Karen Reed said, and that would help the prosecution. Conversely, you could believe what the witnesses said for the defense. You could believe that, you could believe the medical examiner for who the prosecution put the medical examiner up. And you could believe the medical examiner that the medical examiner was unable to tell it was an auto wreck and unable to tell that those were dog scratches or bites, or that they came from a taillight. I should put it that way. If you believe the witness that the prosecution put up, then that could help the defense. And I think that makes it impossible for them to agree. They are fundamentally opposed, and the witnesses go in completely different directions, and they help the other side. So it made for a mess for them to try to agree with each other. It made it impossible for them to do that under those circumstances. So the jurors had to evaluate, do I believe that when Karen Reed said, I effing hate you, John, that she was suggesting she did it intentionally? Or would no one have ever made such a statement after killing someone because it would implicate them? Would it be absolutely crazy to do? So those sorts of issues led to what I think the jurors were talking about when they said they were starkly divided. And I think the reason for that is that they cannot agree on whether she hit him at all. And that is such a fundamental issue. And for the defense side, it's a matter of whether or not the prosecution can be trusted at all, whether or not the police or the troopers could be trusted at all. So that is my opinion on why it is so difficult. I am looking forward to talking to y'all about this. I want to cover one more topic first. I want to talk about where we're headed next, and then we'll get into questions. So hold your questions one more minute, if you would. What will happen next? The prosecution has the ability to drop the case right now. Karen Reed's team pushed for going ahead and getting the jury, giving this charge, the dynamite charge to the jury, going ahead and pushing them toward either a verdict or, as it was pretty clear, more likely a hung jury. They seem to be satisfied with that, with the hung jury, with the mistrial. Karen Reed's team seems satisfied with that. One reason may be that they're hoping the prosecutors will choose to drop the case. It's a controversial case, without question. It will be expensive to retry it. And the prosecution is not particularly likely to win next time either. Not that they won't have presented a case or even a better case, but that they are not likely to convince all 12 jurors for their side. And that's what it will take to convict Karen Reed. But if Karen Reed was hoping that would be the way it went, that the prosecutors would drop it, it appears that would be a false hope, because they've said they are planning to forge ahead. They are planning to move forward. The Norfolk District Attorney's Office released a statement saying, first, we thank the O'Keefe family for their commitment and dedication to this long process. They maintain sight of the true core of this case, to find justice for John O'Keefe. The Commonwealth intends to retry the case. And the defense said, well, we'll be there. We will show up. Defense attorney Alan Jackson said, and guess what? They failed. They failed miserably, and they'll continue to fail no matter how long it takes, no matter how long they keep trying. We will not stop fighting. We have no quit. And so the two sides, once again, planning to tee it up, go forward to a trial, at least according to the way they're talking right now. I think that they will reassess and make, of course, new opinions as they interview jurors, as they talk to jurors about what exactly the issues were that they saw in the case. But that's pretty much what I would have guessed, is that the prosecution would push forward. The defense doesn't really have a choice. They get pulled along. If they keep going, then they keep going. There's not really a lot of question in that. So let me head over, and thank you, Jen, Ken. I appreciate that very much. So let me go into the chat, and I'm going to be looking for questions now. So if you would put question marks at the beginning, I have a much better shot of finding your question. So Annie K wants to know, do you foresee any future trial having lesser charges and a streamlined prosecution case? I don't, Annie K, and here's why. It's not just that the charges, whether the charges are good, but the evidence that comes with the charges. So for example, that second-degree murder and the intent was the ticket to get in some of the evidence that the prosecution really wanted to get in about the relationship between John and Karen, and potentially even the Brian Higgins situation. So those things were critically important to the prosecution, and they wanted to get that evidence in. The lovey-dovey text messages that Karen and Brian had, the suggestion that they had had a fight in Aruba, that they had had a fight even that very day. They wanted that in evidence, and this is the way they get it in. So for them to drop those charges would mean they would have to rethink, are we going to be able to get all the evidence in that we think is important? So my guess, if they're going to try it, they'll try it again on all charges. I mean, obviously, we'll wait and see, and who knows, but that would be my guess. Nestle TD wants to know, do you think jurors were negatively impacted by the protests, even for the jurors leaning towards not guilty? Nestle, that's a good point. I do think it has some impact on the jurors. I think it gives them an idea of what the community is thinking. Obviously, they're not supposed to include that in their decision. They're supposed to focus on the evidence in the case. I feel sure that they tried very, very hard to do that. Does it have some subliminal effect as people see it and they don't consciously take it in, but they do notice it? Probably yes, it probably has some effect. One of the things the judge did to decrease that was set a perimeter around the courthouse where people were not allowed to come inside that to protest. They had to stay a certain distance. But nonetheless, as you drive to or from the courthouse, of course, you would see the people and the protesters. Gator Girl asks, will Jackson and Yannetti stay on the case? I think so. We know that Yannetti is going to show up at the July hearing. We already heard from Jackson that he and the other defense lawyer, Miss Little, are not going to be there. They have another matter on the day the judge is set. So that'll be, but I think they'll all be involved. It only makes sense. They already know the case. It would be incredibly expensive to get someone else up to speed, but it will be very, very expensive, really pricey. I honestly, I can't even imagine how they charge for that. Many defense lawyers charge $1,000 an hour. So imagine 12 hours a day working, because it's not just while you're at court, it's also the preparation that happens beforehand as you prepare to cross-examine witnesses. So 12 hours a day, 6 days a week for 8 weeks. It's just overwhelming how much it would cost to have all of them there. Okay, Verified Vegan wants to know, could the FBI findings change the DA's decision to retry? In my view, the answer is yes, it could and probably should, but that it won't. And part of the reason is I think there's a lot of bad blood between the DA and the feds. You could see that in the letters they were writing to each other. You could see how angry the DA was about what was happening, about the oversight that the feds were trying to have, and how outraged the DA was about that. So will that change the decision to retry? I'm guessing not. All right, Dodd's Discussions wants to know, do you think they will have a new trial or will they give up? I think that they will have a new trial. That would be my guess. I don't think they'll give up, but we'll all be curious to watch that. I know we all will. I'm curious whether you would like to cover the trial in detail again. My guess is yes, but go ahead and put that in the chat or the comments. Yes, I would like more, or just occasional. Kind of let me know your thoughts on that. Mary Lurvey asked me, isn't it likely to be exceptionally difficult to find a whole new slate of jurors who know nothing about this case? Indeed, it will be hard to find that. There's been so much publicity, so much coverage, not just internationally or nationally, not just on YouTube, but of course, locally. Everyone has seen and heard and read about it. I would not think many people would not. But that isn't actually going to be the touchstone. What they're going to look for is not, have you ever heard of it, but have you already formed an opinion? So they could still have jurors who had heard about the case, and they could still sit on the case and they could still be jurors. But it will be far more difficult to find jurors who have not formed an opinion than it was before. The jury selection process will be a lot more difficult. All right, let's see. M&T's Yaya is saying that the state of Massachusetts, 40-year resident, does not have any readback of testimony. Jurors are heavily cautioned about allowing it and are to go on their collective memory. That was one of the things the judge informed them. You're right, M&T, that you aren't going to get a transcript. You can't just ask to hear about testimony. You can have evidence. You can look at evidence, but not a transcript. You can't rehear what a person said. That is, of course, traditional, because in the olden days of just 30 years ago, then there was a court reporter who typed things into her machine, but there was no real way to read that back on a real time or quick basis. They could read back a question or two, but trying to read the whole thing would be virtually impossible. It took a fair amount of work to get it from that format to something you could read. You often wouldn't have a transcript for months after the case concluded, but that's not the way it is anymore. Now, of course, they often use, and this court reporter used a mask where they talk into it and it does some real-time transcription, so it would be possible. We saw in the Traconis case that they actually allowed the jury to rehear parts of testimony, but not a thing in Massachusetts, so thank you. And Chris Conley, hey Chris, thanks for reminding me that leaving Norfolk County and Massachusetts in general was the best choice I've ever made. Well, I will say this, having lived in Massachusetts, I was utterly unable to stay in Massachusetts. It was way too cold for my blood. I am definitely a Southern girl, could not handle it. So thanks, Chris, I appreciate it. All right, so let's head back over and get some more questions. All right. Aisha is asking me, did we rank the 1 to 5 count of the prosecution evidence? Okay. So here's the thing. I think it'd be kind of hard for us to count that. What I'll do, if that interested y'all, I'll do a separate poll on that on YouTube, and we can actually get a count. So look for that. I'll do a separate poll on that. Thanks for the request, Aisha. And Loretta asking me, would you please explain jury nullification? So the process would be if the jury believes that the elements have been met, but just thinks it's not the right thing to do to convict the defendant, then acting outside the law, they conclude that the defendant is not guilty. So that's basically what the process is. I don't believe any of that happened in this case. I believe that there was an honest difference about whether she was guilty at all. Not just that they decided, for example, to punish the prosecution because of the underhanded treatment of Karen Reed. I think they really disagreed fundamentally on whether or not there was even a wreck, whether or not her car even hit him. Jay asking, will they ask for a change in venue? I don't think so. I said that in our earlier live stream today as well. I don't think they will. The prosecution would not, I don't think. And the defense, I think, believes rightly that they have some strong community support. I don't think they would want or need to transfer it. I think, in fact, that strong community support is one of the things the defense is counting on to ultimately convince the prosecution to stop trying the case, to drop the case, and to allow Karen Reed to go free and to just conclude that it's all over. I think that's what Karen Reed's team would like. Lady Tay, I'm probably saying that wrong. I'm very sorry. We'll just go with Lady. Do you think the result would have been different had the jury been sequestered from the beginning? I don't think so. I really do. If you look at the chats, because I was in a number of chats, watching as the trial went on, and uniformly, there were huge differences in what people thought about the case. There were people who firmly believed that Karen Reed was guilty, that she hit John O'Keefe, that she maybe knew it, but she for sure did it, and she should be convicted of that. Then there was a large group that concluded that she absolutely was not guilty. She'd been framed, and that in any event, there wasn't enough evidence to convict her on those charges. So I think that that was significant. And I think that difference of opinion was reflected in the jury. It wasn't that they had different opinions. It was that they showed really the same sorts of opinions that we saw in the general public, which I do think the prosecution ought to pay attention to. I think the prosecution ought to recognize that, but it doesn't appear that they are. Rick was arguing it was a conspiracy, a bad move by the defense. Now the conspiracy has to be believed rather than just reasonable doubt. That's an interesting point, Rick, because they did introduce this element of the conspiracy around them and all of the planting of evidence, all of the suspicious behavior by the people in the house, by the police. And that did introduce sort of something that they arguably had to prove. It clearly, though, I think, led the jury to reasonable doubt. That's what they wanted, and I think they got that. So I think it was a smart move on their part. It might have created some difficulties for them, but it doesn't seem to. It seems to have worked the way they thought it would, the way they wanted it to. Many asking me about Paul going after Karen. I saw that little clip, and I saw what people said that Paul said, which was, I don't even remember what it was, but something Karen like, we'll come back or something. I'll be back. I can't remember exactly what it was, but I honestly, he barely moved his lips and then he turned away. I didn't see how he could have possibly said all of that. I just didn't get it. So I don't know. I know that other people felt that he said that his wife said, "Oh, stop it," and pulled him away. Obviously, it would be a very tense moment for everyone. And you did see Karen Reed's face change after she turned back away from him. So there may have been something said, but I could not tell it. And so I thought there was a lot of speculation around that I just couldn't support or not support. I didn't have any idea what was being said. Dr. Kara asking about the trial in another district. I don't think they'll do that. I think they'll come back where they are. Night Owl, can the grand jury overturn this case? And no, the answer is the grand jury has already made its decision that there was enough evidence to go to a trial jury. So the next step will be another trial jury and another trial. That'll be what happens next. Now, there may be a federal grand jury that meets that hasn't completed its work, but I think the federal grand jury has completed its work and it's now up to the federal to the feds, to the district, to the United States attorney to make the decision about what they're going to do in terms of charges, if anything. A-Light asking, how can the defense get a change of venue? And I think it's unlikely, as I said. Girl asking, what do you think of Karen Reed's demeanor during the trial and the jury effect, if any? So for the most part, I thought she was pretty stoic, not a lot of reaction. We saw some reaction at least once in front of the judge that really infuriated the judge, but I didn't see a lot of that in front of the jury. I heard comments that one juror may have complained about her demeanor, but I wasn't able to find any actual report of that, just sort of rumors of that. So I don't know if there was any kind of sense of that. I certainly didn't pick it up, but they showed her so rarely as they were panning back and forth that I easily can miss it. I think people who were literally present in the courtroom would probably have the best view, although frankly, they were behind her too, so it might have been hard for them to see. Okay, KS asking, even though the Commonwealth says they will retry, is it possible they will not go forward? That is a really interesting question, KS. And I think the answer to that is yes. I think that it's possible they won't go forward. One of the things that might change their minds would be talking to the jurors. And if they find there were 9 or 10 jurors for Karen Reed, 2 or 3 against, 2 or 3 for them, in other words, then maybe that starts to persuade them. Maybe they start to think about it. But I think right now they've already drawn the 2 camps are opposed. And I think it's going to be hard for them to back down on that. They've already made the statement that they plan to go forward. My guess is that they will. So that is my best guess of that. Zakia wants to know, can all evidence and testimony be used in the second trial? It can, unless there's some reason for the judge to change a ruling. For example, if there were some piece of evidence and now that she sees it in context, she says that really wasn't relevant, I shouldn't have let it in. She could change her mind and rule against it. One difference will be, of course, there won't be any surprises in terms of evidence unless there's something new we don't know about. So anything that was a surprise before will be something they already know about. Okay wants to know, do you think the jurors will go on national TV? I hope they will go on the Lawyer Lee channel on YouTube. Please, if you know any juror who would be interested in talking, I would love to interview them. I would like to know more about what they thought, what the arguments were, what their beliefs were about the evidence. I would really be interested. So will they go on national TV? I don't know, but hopefully they will be on the Lawyer Lee channel. That's what we would love to have. Okay, so let's see. Tracy asking, what new evidence could the prosecution possibly have? Will they change their story on how she hit him? I don't think they'll have truly new evidence, Tracy. I do think they might have not new evidence, but a new way of presenting it. For example, maybe Trooper Paul would be better prepared, or maybe they have maybe they could hire a new expert reconstructionist who could actually talk about how the wreck occurred. I thought that was a huge problem and a big missed opportunity for the Commonwealth. I thought they really needed to show how that accident happened, and they did not do that, and that was a shame. So Kara is asking me, can the jurors talk or be prevented to because of the hung jury? And she had heard that the foreman was a police officer and one was a lawyer. I thought, I wouldn't be surprised if there was a lawyer. The way that things were written when it came out from the jury was really legal. I thought, wow, that sounds just like I said in my earlier one. It sounds like a lawyer wrote it. And so that wouldn't surprise me. It also wouldn't surprise me if the foreman was a police officer and if the foreman was on the side of believed that Karen Reed was guilty beyond a reasonable doubt. Remember, I said earlier in the video, you can back up to see it if you are coming in late, but I said, I really thought that the way that it was phrased, that the people who believed, the prosecution believed it firmly, and that word wasn't used with the other group, not that it was anything that made them less certain or less of a difference or denigrated them in any way. But I did think it sounded like maybe the person who wrote it was on that side. So that was my theory on that one. All right. Well, let's see. I'll do one or two more questions and then we'll call. Oh, I want to tell you about what we're going to be doing tomorrow because it's going to be pretty exciting. I have 3 more videos queued up on this case. One we're going to be doing tomorrow is we're going to be doing a series of 2 on the third party culprit. Remember how we've heard and got evidence in this case about other people who might have been involved in the murder of John O'Keefe. These were people who were inside the house. So what I want to do is, using the timeline that we put together, that the members helped me put together, I'm going to try to dissect what is the evidence that Colin Albert had anything to do with this. Is there any evidence or not? Remember that the defense did not mention him, not a word about Colin Albert in the closing arguments. On the other hand, the defense did mention Brian Higgins, and we're also going to be doing a separate video where I will dissect the evidence about Brian Higgins and whether or not he had any involvement. What does the defense say about his involvement? What do we know about it? Does any of it fit? How does it fit with the facts? We're going to be looking at that with our timeline. We're also going to be pulling out some clips from what was said at trial. So that'll be really interesting. And I am looking forward to that. We're going to be going live tomorrow night, extra session tomorrow night at 7 p.m. Eastern. We normally go Monday, Wednesday, and Friday at 7 p.m. Eastern. So one of the things that would be really helpful to me is knowing whether you are interested in the Alec Baldwin case. If you would give me Alec yes or Alec no in the chat or the comments, that will help me sort of know what you're thinking and whether that particularly interests you. We will definitely be talking about the Curry Richens case coming up soon. And let me see. Oh, great. We have another new member. Sarah, welcome. So glad. And Cinderella, thank you very much for your super chat. I appreciate that. So I was going to do 1 or 2 more questions and then we will head on out, and I'll see you tomorrow at 7 p.m. Eastern. So let's see. Oh, Maria also asking me my opinion. Okay, so I said it. I was going to hold out on y'all because I am somewhat of 2 minds on this one. Linda, do you think that, okay, so y'all were not going to let me forget, were you? No one was going to let me forget. All right, reclined. How do you think they will get a truthful jury now that the whole world has been watching? It will be more challenging to pick a jury. I would think it would take longer, and they're going to have to really find people who have not formed an opinion. and are not going to lie about having formed an opinion or downplay the fact that maybe they really do have an opinion and they don't want to because they'd love to sit on this jury, for example. Leona wants to know who's paying for Karen's defense. I believe her dad is at least partly involved. There was also, I think, a GoFundMe that covered some of the expenses, but this is extremely expensive. I can't tell you. The ordinary individual could not mount a defense even remotely like what she has mounted. It would be really difficult, and that is a problem in our system. It just frankly is. Jenny wants to know, do I think the defense focused in on their specific theory a bit too much? I think they did. They tried a great case. I think it would be hard to argue with their success, would be the bottom line. And Kenneth wants to know, what were the FBI findings? And Kenneth, I would like to know that too. I think we all would. All right. Well, I will see you tomorrow at 7 p.m.